Good afternoon. Today is Friday, April 10th. So everyone, I just want to tell you, you have your vote list here. And if you notice, there's only 2 bills on this vote list. We are going to do that last. Before that, we're going to do our concurrence calendar. Our first item up to bid is House Bill 501. And the bill has been amended in the Senate. So we have a motion to concur if the body so chooses. Thank you. Thank you. And the changes are mostly reducing the maximum penalties.
Yes. Or misdemeanor?
So actually, it is a misdemeanor already. And
Went down to a fine. Misdemeanor.
I forgot who this is. This is Claire, I think. Hold on. We'll tell you all about it. Just a moment.
Okay, so there's 3 different tiered offenses in the bill, and for the first one, it's just the simple person in a position of authority crime that's under existing law. A person in a position of authority may not engage in a sexual act or sexual contact. Or
Excuse me, Claire, can you speak a little closer to the mic?
Okay. Basically, engaging in sexual activity or sexual intercourse with a student at the school where the person or is under the supervision, basically, of the person in a position of authority. And that's basically for 16 and 17-year-olds. So that maximum penalty is reduced to 1 year incarceration, and that's what it is under current law. And then for the bill's creating a new offense of a person in a position of authority may not engage in sexual activity involving a child under the age of 13. That is a felony under the bill, and so the amendment is reducing the maximum penalty for that from 15 to 10 years. And then the third newly created offense is basically a repeat offender under the bill. That's a felony. The amendment is reducing the maximum penalty for that from 25 years to 20 years.
Delegate Archon.
Thank you, Madam Chair. Claire, can you just explain this? My understanding with the impetus of this bill was, is this a security guard situation where
No, this isn't the school resource officer.
Okay, so we have a separate bill because I wanted to make sure that we were also covering 18,
we're also covering
18-year-olds or above, because nobody in position of authority should be taking advantage of children in schools, even if they're over 18, right?
I would agree with the sentiment of that, yes.
Okay.
So we're talking about someone who is in a position of authority. That person is at least 21 years old.
Right.
And works for some form of remuneration or is a volunteer.
Okay.
And then we're only talking about preschool, elementary school, or secondary school.
It only covers minors, which means under 18.
Okay.
So this does not cover 18-year-old victims.
Okay, I got you, but the school resource officer one does?
The school resource officer bill, I can't speak to. Delegate Simpson, do you recall on the school resource officer, if it's just a minor?
For my bill?
Yes.
My bill is that it can't be sex with a student. So the student could possibly be, which is what they had done before, was groom them until they turned 18. Mm-hmm. So it covers what already is covered by it. That this was a loophole because most of them don't actually work for the school. Right, so all the school, we did all that before, so what our school resource officer says, you can't with a student. So the student could be over 18.
Okay, good. I just want to make sure that those kids were also protected because that's still predatory.
No sex with students.
Yeah, that's a very basic rule. Hear that, boys?
Yeah. All right, Delegate Conaway.
Thank you, Chair. Can council explain one more time on the change from the 15 to the 10?
Yes.
What's the current penalty right now?
So currently it's, Claire, I don't know if you could hear the question. The question is, you all, it's really hard to hear if you have your own personal conversations. We can meet afterwards and everybody can have their personal conversations, but right now it's very important to be able to listen. Claire, what is, the question is, with respect to, I guess it's Amendment 2, with respect to the reduction from 15 to 10.
Well, under 3308, which is fourth-degree sex offense, currently, everything under that is a misdemeanor punishable by up to 1 year imprisonment. And so this 15 to 10 is basically taking that 1 year misdemeanor up to a 10-year felony if the victim is under 13. But that's for if the prosecution cannot prove force. This is for so-called consensual, I mean, if the prosecution can't prove force. If they could get them under one of the other existing felonies.
Thank you very much.
Are there any other questions? Delegate McComas?
Okay, this is once again off topic in a sense, but my question is, has the sexual, dealing with sexual offenders, has the treatment and process improved over when I was first elected? Because they were using Depo-Provera and Fred Berlin and all that stuff. In other words, is it improved? Because my concern is a lot of times these folks go back to the being predatory. So I sort of, and they've got all these other, advantages of dim credits and everything and good behavior and stuff and their parole hearings. So my concern is only if the punishment and the treatment has improved so that they're not a danger, I'm okay with changing it. But if not, if things haven't improved and there's still, we can't do anything to fix it and stop it, I'd say just leave it the way it was, the 15 as opposed to the 10 and the 25 instead of the 20.
Well, thank you. I don't know the answers to any of your questions. I didn't mean to say that like that. What I mean is I don't, because in this particular bill, that wasn't part of the testimony other than there might have been under the Families Advocating Intelligent Registries. Let's see if they had anything. They might have something in there that goes to what you're speaking of, because they're going to talk about the fact that the punishment may be too harsh. And so if you look at that, you might get to see some of the treatment now. Yep. Okay. So are there any other questions? Seeing none, please call the roll. This is House Bill 501. I'm sorry, this is a hand vote on, wait, this is a concurrence. Okay, all right. Delegate Moon?
I'm sorry.
We moved to concur, and we have a second, and now we have a question. Delegate Moon?
Sorry, I'm just trying to line this up with the regular sex assault penalties and the age brackets. Is your version of the bill, or is the Senate's version of the bill more in alignment with current law on how we treat a sex offense against a person under 13 or whatever. Does that make sense? Like if they were not in a school and whatever, the context that we're.
Just a person who was out and about?
Yes, exactly.
Okay. That's a good question. I don't know if I know the answer to that at this moment, but I'm gonna make a note, because I think that's a great question. And I'd have to look up the code to see for sure.
I guess the question is, what is the penalty for a sex assault against a person under that age that doesn't involve force and is not in a school context?
Yep. So,
By a person be in a
Not
position
in
of authority.
not in a position of authority.
Right, but they could, in theory, if they were in a school, it would, an analogous situation. You have an older person who, in theory, could be a person of authority, but because they're out of the school context, it's just, is that what you're asking? It's like,
Yeah.
it's just an older
If
person
it's-
and a younger person.
Correct. If it's not, right, an older person, a younger, same age brackets, but not at school, what's the penalty for that?
And would it be different if he was a teacher versus he was a construction person? A
It's
construction.
above in your, it's on page 3 of the bill.
we're getting I'm getting a chart that I will be more than happy to share with you all in just a moment.
Under, starts at line 3, or page 3 and 5, yeah, and
It really depends on the nature of the act.
Meaning that for certain, so we go into things as just mere touching, is that what you mean by the nature of the act?
Yeah.
Okay, all right.
right, but that section is about if you are not in a position of authority, you may not engage in, and then it gives kind of somewhat, not exactly, but the things that are below as well, but it does depend on how far it goes and how old the child is.
Yeah,
Because, Madam Chair, you were proposing 15 years if they were under,
if the child was under 13.
right, and that seems like a pretty serious offense. And I guess then my question is, if we're going lower than that, then I do want to know what the number was for that happening not in the school context.
Okay.
Just whether we're making it the same or not.
All right. Well, we have some data on the fiscal note where we get into sexual act with a minor, and as to what Claire was saying. Hold on. So we have, okay, so let me just make sure I can go to this much. I might not be getting to your question yet, but I think maybe we'll talk it through and get there. So a tier 1 sex offender has oh no, that's not gonna work for you. Hold on.
A felony with what maximum, 20?
If the child's under 14. Yeah. Yeah.
Mr. Jordan says 10 years, but then you're right. If they're over 20, it's usually 10 years.
But if they're
But if you're
under,
having sex with them.
So it's 10 years for, so Claire, you were right on the 10 years for the 3rd degree sex offense if the adult is over 21 years currently
That's
in
for
law.
sexual acts and sexual contact.
Right.
Not intercourse,
I mean, just sexual contact.
yeah.
so it sounds like it's higher for intercourse than for,
Oh, it is higher for intercourse. Yeah.
okay, sorry, I feel like I've been doing this a lot lately, but Madam Chair, it's your bill, so I'll roll with what you want to do on it.
Yeah. Okay, so I still want to know the answer to your question, and I will look it up and I'll talk to Claire and get more guidance on the answer to your question. But I believe it is, we were trying to align it, or we might have increased it simply because the person is a person of authority and that trust factor has been abused. Delegate Conaway?
Yeah, I just want to be clear, for the third-degree sex offense, what's the current statute on that? What's that current?
For third degree?
Yes.
Well-
Of the minor.
Of a minor. So what we have, I'm getting some notes from a state's attorney just to get
Oh,
some
yes,
information here.
Yes, ma'am.
So second degree rape is 20 years. Third degree and second offense is 10 years, depending on the age of the child and the offender. And a nice little sheet, and she's looking for the most updated chart, would be helpful. Let me hold this, and so I can get my answers and give you guys, because I don't want to confuse the public either. Delegate Moon?
Throw one more question in there
Yep.
then before we shut it.
Yep.
I have the same question if there's a merger question here. If you have a 20-year penalty for second-degree sex offense.
Hold on, I can't hear you guys.
If you have a merger question, if the existing penalty for a second-degree sex offense against a person 13 years old is 20, and they happen to also be in the supervisory context or whatever contemplated in the bill, do they maybe then face the 10 because it's intercourse, but it also falls under this bill?
So wait, I couldn't hear all of your question. Say it again, please.
Is there a merger question? Because you can charge them with either of these if it was intercourse with someone under 13. If they were strangers, then they could face 20 years for that. But if they were the tutor or whatever, I don't know, I forget what
Right.
what
Yeah,
you're calling it in
tutor
this
would-
bill, then it might be 10. It might be 10. It actually might be 15 as introduced, but it would be 10 with the Senate amendment. So at least for that set of people, I have that, at least flag that question down, whether we could.
Charge for the same facts, right?
Well, that's what he was asking.
Yeah, that's the question, right?
Lesser included.
Ah, there is.
Yeah, there
Okay,
is that.
never mind then, I
Yeah.
withdraw.
I do remember that. Okay. All right. Are we still good with our camera? Okay. All right. Let me get back to you. I want to get back to you on how does this align with any other sexual acts with a minor within, the same content. So I'll get back to you on that before we finish today. All right, let's move on to Senate Bill 514. Yesterday on House Bill 907, we voted not to receive, and there were, because there were some differences in the language, so we decided not to recede. And on Senate Bill 514, which is the cross-file of House Bill 907, I'd like to know your pleasure if you'd like to continue not to recede, so they can be in the same posture. So yeah, today's bill is Senate Bill 514, criminal law, third-degree assault. So we could vote not to recede, as we did with House Bill 907.
That would be the same conference committee, wouldn't it?
Yes. Yes. Everything's the same? Okay. All right. Okay. Is there a second? Thank you. Can we just do the same that we did yesterday? This will go to conference. All in favor of the motion not to recede, please raise your hands. All right, it looks like there's no one opposed. Or is there? All right. We're going to move on to our second bill, House Bill 219. This is House Bill 1219. We were jointly assigned with ENT, and ENT voted out our bill.
Just say who the conferees were.
Oh, I didn't know I thought I wasn't going to say it. I can say it. Okay. All right, I'll go back to that in just a second. So on House Bill 1219 was in the Senate. Was in the Environment and Transportation. They voted it out. This is a bill on climate change. And what they did was they added representatives from the Independent Insurance Agents of Maryland, and also designated by the Independent Insurance Agents of Maryland. So is there a motion to concur with, thank you, with the Senate amendments? Is there a second? All righty. Is there any opposition to concur with the Senate amendments? Please raise your hands if you are in favor of concurring with the Senate amendments. All right, if you're opposed, please raise your hand.
Really?
It's climate change.
Yeah, it was
Okay.
voted out on part.
That's fine, that's fine.
The title was problematic.
Okay. All right, moving on. I'm going to circle back to, we just talked about Senate Bill 514, and the conference committee members are going to be Delegate Cardin, and Delegate Valentine.
Really?
And that, young man, is your punishment for the day. Okay. Okay, we're going to move on to House Bill 351. House Bill 351. Okay, is the question which was the one that you're on the conference committee for? Yes. You're on for Senate Bill 514 and House Bill 907. Okay, now we're going to go to House Bill 351, and this is public safety. And I'm going to let Holly talk about the bill.
Chair, we're on 351? Yes. It's just concurring with the Senate Bill 346, which passed out of the House yesterday. So we just want to concur. Thank you.
Thank you. Are there any questions? All in favor of a motion to concur, please raise your hands. This is, yep, okay. All opposed, please raise your hands. All right, thank you. The motion passed. All right, we're going to move on now to House Bill 426. This goes with this. And this is also a motion to concur for House Bill 426, because we had, the changes are slight. And I think this is, Holly, could you explain? If there's
426
426.
It's a Delegate Long bill, J. Long, and he approves of the amendments. The amendments are an MSBA and a Maryland Legal Aid Amendment. One allows the guardianship stay to be extended for good cause shown. And the other amendment, MSBA, wanted to clarify the notification requirements to make it more clear who receives the notice and when the parties should receive it. It's when the action is sought. And so that's just clarifying. So we're just moving to concur with what the Senate did to it. It doesn't have a cross file.
Wait, I have a question.
Thank you. Delegate Erica, you have a question?
Yeah, can you just explain to us again what they did with Maryland Legal Aid?
Yeah.
Was that, I don't see it in, I'm looking at the third reading, which I guess is not going to have those changes in it yet.
No, it's going to be, and you'll see if you go to the floor system, it'll be in their amendment request. We had it on this side. The delegate had asked to move it clean because it had in years past, and he wasn't sure what would happen when it got to the Senate. But the Senate wanted these amendments, and again, he's okay with it now. So, give me 1 second. Okay. So on page 2 of the bill, in line 24, you might not see it because I'm not sure where it is, but on line 24 of the bill, page 2, it says, this is going to be the part of the MSBA amendment. Within 90 days after filing the petition, or the period of stay determined under subsection C1 of the section. So then go to page 3, subsection C, and then you're going to see, unless extended for good cause shown, a stay under subsection A.
Okay.
And then you're going to see the MSBA one here. The stay under subsection A shall be automatically lifted.
Oh, okay.
Okay?
Yep, I see it. All right. Yeah, thank you.
Great. Are there any other questions? All right, seeing none, we have a motion to concur and a second. All in favor of the motion to concur, please raise your hand. All right, all opposed? The motion carries. All right, we're going to move on now to House Bill 497. This is the temporary and final protective orders, duration and relief. The Senate made a minor change, correct? To just put in after service of the order. They changed it from after service of the order to after issuance of the order to conform to current practice. Is there a motion to concur?
So moved. Second.
Thank you. Are there any questions? Yes, Delegate
It
Carter.
seemed to me that usually they're not effective until after they're served. I'm not sure why they changed it from service to issuance. But if they think that's the right way to do it, I'm just curious.
Yeah,
Right?
and in fact, Delegate Simpson has an answer.
Yeah,
Yes.
please.
Actually, it is really kind of funny because it is Maryland Judiciary that really kind of inserted this and said that it's been written wrong forever, and can you just fix this while you got it open? So there you are.
Okay, love it. You go. You go, Judiciary, you go.
Right.
All right.
I think it's funny too, because you would have thought the whole world would have fallen on its head and how many years that it's been like that, but apparently the police were able to kind of figure this out, what they were doing in the courts, but they'd like to read it correctly, so.
All righty.
Shall
Well,
we concur?
with that said, there's a motion to concur on the books. Delegate McComas, do you want to have a question?
You read my mind.
Yes.
I get. How is the, okay, it's okay if it's the issuance of the order, but the problem is what if the police or whoever's supposed to give it to that person doesn't do it very quickly? And I just think there's a problem there. I think it should be the person gets served as opposed to the issuance, because, you know, we've talked about all that stuff. We can't control different things and all that. And this is a case where you can't, you know, the police are going to be different than the judge issuing it. And you know, the criminal justice system is so, it's not seamless. Everybody does their own thing, and that's my concern, is for the.
I sympathize with you, and it makes sense. But I will say that in the bill, or actually current law, that the judge may always extend the time if service has not been effectuated. So they can always extend as needed, but as long as it's not more than 6 months. Okay. Oh, no, I get it.
I just think it could have some problems.
I get it. Any other questions? Is that your copy? Thoughts, concerns? Giving everyone time to ponder. All right. All those in favor of the motion to concur with the Senate amendments, please raise your hands. All right, all opposed? The motion carries. All right, so we'll move on with that one. Now we're going to go to, okay, we're going to take care of two bills here. We're going to take care of House Bill 563 and House Bill 563. The Senate made amendments to House Bill 563. This is the Criminal Law Emergency Response Animal Prohibited Acts Against. So the Senate amendments, this is just great. I'm just going to read it. Okay, I'll just read it. This is great. The Senate amendments specify that the defendant is not prohibited from asserting the defense of necessity and allows and alters the penalty of the bill to provide that both a violation committed during the commission of another crime and killing or causing serious physical injury to an emergency response animal are subject to a maximum fine of $10,000 and a maximum term of imprisonment of 2 years. But the good news is that it remains, they have retained the self-defense language that we had, that we liked. And this, in fact, reduces the penalties with this amendment. It's a misdemeanor. Okay, now mind you, keep in mind, these are always the maximums. Okay. This is a motion to concur, okay? And Delegate Conaway, did you have a question?
My colleague and I, we were reminiscing that because of the value of the dog, that helped to bring the $10,000 figure up. Because of the training, the dog, yeah, for the dog, yes. Because that was a steep number, but years ago, we brought that number up because of the value of the dog, yes. Thank you.
Thank you for that. Do we have any questions? Yes, Delegate Valentine.
Thank you, Madam Chair. I'm looking at page 4 or 5 of the reprint, and the other thing they took out the definition of a law enforcement unit. Is there a reason why they would have done that? It is?
It's actually still in.
I'm looking at the reprint of the third reader for the House bill. Is it, or is it?
You gotta look at the. They amended it again.
They amended it?
Floor, yes.
Okay.
It was a floor amendment.
Okay. Thank you.
And that law enforcement's back in.
Okay.
And law enforcement's back in. I love it when neighbors fight. Okay, so, good fences make good neighbors. All right, so the motion is to concur with the Senate bill, with the Senate amendments. And we have that motion and we have a second. All in favor of the motion to concur the House bill with the Senate amendments, please raise your hands. All right, all opposed? All right, the motion carries. Now, we're going to do what you see on your vote list, Senate Bill 360. Yep, move to concur with what we just did. Conform, I'm sorry. Second, I heard a second. Okay, great. So all those in favor of a motion to conform the Senate bill to what so they look the same, please raise your hands. I see hands are raised very eagerly. Thank you very much. The motion passed. All right, we're finished with that one. And we have to take a vote on that. That's what I was just getting ready to say. All right, all in favor, roll call vote on Senate Bill 360 as amended.
Senate Bill 360, Senator Henson, Criminal Law, Emergency Response, Animal Prohibited Actions Against, the Vice Chair. The Vice Chair votes aye, Delegate Valentine. Delegate Valentine votes aye, Delegate Embry. Delegate Embry votes aye, Delegate Cardin. Delegate Cardin has translated his original answer to a yes. Delegate Phillips. Delegate Phillips votes aye, Delegate Congolo. Delegate Congolo votes aye, Delegate Stinnett. Delegate Stinnett votes aye, Delegate Simmons. Delegate Simmons votes aye, Delegate Boucher is absent, Delegate McComas. Delegate McComas votes aye for the critters, Delegate Moreno. Delegate Moreno votes aye, Delegate Archon. Delegate Archon votes aye, Delegate Taylor. Delegate Taylor votes aye, Delegate Simpson. Delegate Simpson votes one wolf and a yes, Delegate Mangione. Delegate Mangione votes aye, Delegate Moon. Delegate Moon votes aye, Delegate Conaway. Delegate Conaway votes aye, Delegate Woods. Delegate Woods votes aye, Delegate Williams. Delegate Williams votes aye. The tally is 18-0-0-0-1. The motion carries.
Thank you very much. Okay, we're going to, just one second. We are going to vote on Senate Bill 512 on the stalking bill that we heard from Senator or Chair Smith. Senate Bill 512. There are no amendments. It's straight favorable. Thank you. And do you have any questions about Senate Bill 512, stalking penalties? All right. You said, could someone remind you what the bill does?
Yes.
Okay.
Just get quick, because I know we passed other stalking bills, and I'm just wondering how this one impacts the ones we already passed this session.
Right. Okay. Claire, would you like to explain what the bill does now? Well, not now, but has always done?
Under current law, stalking is a misdemeanor punishable by up to 5 years imprisonment and/or a fine of up to $5,000. And this bill increases the penalties for stalking in 4 circumstances. And the penalty increase is that it would be a felony, punishable by up to 10 years and/or a $10,000 fine. And the 4 circumstances are: the person had a protective order in effect against the defendant at the time of the offense. The person had a court order against the person prohibiting stalking. The person has the defendant has a previous conviction for stalking, or the defendant has a previous conviction in another state that would constitute stalking in this state.
Okay. Move favorable.
Okay, Delegate Conaway.
Penalty again?
It is a maximum of 10 years or a fine of $10,000 or both. Are there any other questions? Yep, please call the roll.
Senate Bill 512, Senator Smith, criminal law, stalking penalties. The Vice Chair. The Vice Chair votes aye. Delegate Valentine. Delegate Valentine votes aye. Delegate Embry. Delegate Embry votes aye. Delegate Cardin. Delegate Cardin votes aye. Delegate Phillips. Delegate Phillips votes aye. Delegate Congolo. Delegate Congolo votes aye. Delegate Stinnett. Delegate Stinnett votes aye. Delegate Simmons. Delegate Simmons votes aye. Delegate Boucher is absent. Delegate McComas. Delegate McComas votes aye. Delegate Moreno. Delegate Moreno votes aye. Delegate Arcon. Delegate Arcon votes aye. Delegate Taylor. Delegate Taylor. Delegate Taylor votes aye. Delegate Simpson. Delegate Simpson votes aye. Delegate Mangione. Delegate Mangione votes aye. Delegate Moon. Delegate Moon votes aye. Delegate Conaway. Delegate Conaway votes aye. Delegate Woods. Delegate Woods votes aye. Delegate Williams. Delegate Williams votes aye. The tally is 18-0-0-0-1. The motion carries.
All right, real quickly, or I can wait and we can do this tomorrow. 2:15, actually, we can't wait. Can we wait on 2? We got our answer. Okay, Senate Bill 215, Veterans and Uniformed Services, Maryland Veterans Trust Fund and Application of Laws. This was jointly assigned with Ways and Means, GLE, and they voted it out, and it's our turn. Is there a motion? Okay. Are there any questions? Seeing none, please call the roll.
It's a clean bill. It's, yes, yeah. This is just a cleanup bill.
Okay. Please call the roll.
Senate Bill 215, Senator Simon Eyre, Veterans and Uniformed Services, Maryland Veterans Trust Fund and Application of Laws. The Vice Chair. The Vice Chair votes aye. Delegate Valentine. Delegate Valentine votes aye. Delegate Embry. Delegate Embry votes aye. Delegate Cardin. Delegate Cardin votes aye. Delegate Phillips. Delegate Phillips votes aye. Delegate Congolo. Delegate Congolo votes aye. Delegate Stinnett. Delegate Stinnett votes aye. Delegate Simmons. Delegate Simmons votes aye. Delegate Boucher is absent. Delegate McComas. Delegate McComas votes aye. Delegate Moreno. Delegate Moreno votes aye. Delegate Arcon. Delegate Arcon votes aye. Delegate Taylor. Delegate Taylor votes aye. Delegate Simpson. Delegate Simpson votes aye. Delegate Mangione. Delegate Mangione votes aye. Delegate Moon. Delegate Moon votes aye. Delegate Conaway. Delegate Conaway votes aye. Delegate Woods. Delegate Woods votes aye. Delegate Williams. Delegate Williams votes aye. The tally is 18-0-0-0-1. The motion carries.
Thank you. Now, with respect to House Bill 501, I have the information. I have to absorb it. It's a lot. I've gotten my chart, and it's quite a bit. So we're going to hold House Bill 501 until our next vote session, and it is possible that we might have a vote session either this evening, depending on how fast we get out of the floor, or it'll be definitely tomorrow, depending on what time we come into the floor tomorrow, hopefully in the morning. Thank you. We are adjourned.